And then I'll come back to you, Senator Wong. Senator Madigan.
Thank you, Chair. My questions start off in East Timor's oil and gas production. Attorney General, would you agree that there's been no effective foreign policy towards East Timor since 1999 other than for Australia to maximise its access to East Timor's sovereign gas and oil resources?
No, I wouldn't agree with that at all, Senator Madigan. Not at all. I think the professional diplomats who are at the table will be better able than me to express to you the range and depth of the relationship between Australia and East Timor, notwithstanding the fact that there is a dispute between our respective nations in relation to one matter. It is a friendly relationship. Australia is a generous aid donor to East Timor and always has been. But rather than me elaborate in an inexpert way, why don't we have either Mr. Varghese or Mr. Cox perhaps expand on that answer?
Well, perhaps I could start and Mr. Cox may want to add. The relationship for East Timor is one of our most important regional relationships, and it has a number of dimensions to it. We have a very substantial bilateral relationship with East Timor, including, as the Attorney General has just indicated, a substantial aid program, but also a broader political dialogue. We work with East Timor closely on a range of economic and development issues. We have a trilateral mechanism that brings together East Timor, Indonesia and Australia, which meets at foreign minister level, and we consider it to be a close and fairly broadly based relationship, and certainly not one which only runs on the one track that you mentioned.
Right, thank you, Mr. Varghese. With East Timor's current oil and gas production likely to cease by 2026, is it not in the long-term strategic interest of Australia to assist East Timor to become a stable and prosperous country?
Well, that's very much in our interests for East Timor to become a stable and a prosperous country, and one of the reasons why we have negotiated the agreements that we have with East Timor is to provide a certain legal framework, in other words, a legal framework with a large measure of legal certainty, which would enable the maximum exploitation of the resources in the area. That has been the basis of our treaty negotiations, both in terms of CMATs and the Timor Sea Treaty.
Right, thanks, Mr. Varghese.
As you might be aware, Senator, Timor-Leste has accumulated petroleum wealth, sovereign wealth fund of $16.1 billion, based on the wealth from the joint development area, of which they earn 90% of the upstream revenue.
So would it not be in the immediate strategic interest of Australia to allow East Timor to resolve the question of their national sovereignty of seabed resources before the International Court of Justice according to law?
Well, Senator Madigan, there are no proceedings currently on foot before the International Court of Justice. There is, as Mr. Varghese said in answer to questions from another senator before lunch, there is an arbitration which is currently suspended, which has been commenced by East Timor and may resume. But Australia is not creating any impediment to East Timor exploiting its resources. There are two treaties in particular, the Timor Sea Treaty and the CMATs Treaty, which actually provide a framework within which those resources are able to be exploited to the benefit of both countries, and as you've just heard Mr Cox say, in relation to the resource that is currently, I think Mr Cox was referring to this, is currently being exploited. The split is 90-10 in East Timor's favour.
Attorney General, do you conduct state-to-state correspondence in relation to Australia's international strategic, security and economic interests?
Me personally? Ordinarily no, although in relation to the legal proceedings to which I have referred, correspondence with the legal agent, as it's called, of East Timor from the Australian agent is usually authorised by me.
Attorney, on the 26th of May 2015, I believe you wrote to the East Timorese Minister, Mr Aju Pereira, stating that Australia recognises the need for all states to respect the confidentiality of communications between states and their legal advisers, consistent with the widely accepted principle of legal professional privilege. Is that right?
Yes, that was an issue that had been raised in ICJ proceedings, and it bears upon, or it may potentially bear upon an issue in the arbitration.
Attorney, would you agree that this letter was written in the hope that East Timor would discontinue proceedings at the International Court of Justice?
Well, East Timor in fact did discontinue proceedings that it had commenced in the ICJ. Those proceedings were settled and they have now been disposed of.
Right. Attorney, would you agree that your assurance of the 26th of May did not embrace any future bilateral negotiations concerning the maritime delimitation or any other related procedure between the two states, including the present case before the International Court? In other words, Attorney, was East Timor misled into discontinuing proceedings in 2015 when the only assurance given related to communications between legal advisers being legally privileged communications?
No, Senator, you have the better of me because I don't have a copy of the letter in front of me and it's not a letter I've seen for nearly a year. But, Senator, that letter was written with a view to providing certain assurances so that the ICJ proceedings could be settled, and they were, to the mutual satisfaction of both parties. There are no ICJ proceedings on foot at the moment. I think perhaps you may be referring to the arbitration proceedings, which are on foot but are not current in the sense that they've been adjourned. They were adjourned some while ago. But the letter from which you have quoted was a letter that was sent in the course of arriving at a resolution of the ICJ proceedings.
Attorney, was the current Secretary of your department, Mr Chris Moratis, a senior DFAT officer in October 2004?
Well, I know Mr Moratis's professional background has been as a DFAT officer. That is what he was at the time he came to be the Secretary of my department in 2014. Whether he was a DFAT officer in 2004, I'm not sure. I think he was. I think you're probably right, Senator, but I don't have a resume of Mr Moratis's career to hand. Perhaps one of the officers at the table might know from their own personal knowledge of Mr Moratis.
He was a Foreign Affairs and Trade officer in 2004.
Right, thank you, Mr Verghese. Attorney, was Mr Moratis a member of the delegation from Australia in Dili in 2004 in October, during which is alleged clandestine listening devices had been installed by ASIS in the East Timorese Ministerial Cabinet Room.
Well, let's decouple the two parts of that question, Senator.
Right.
The allegation with which I'm familiar is not an allegation that Australia has ever accepted. Whether Mr Moretus travelled to East Timor at that time, I'm not aware. I'll take that on notice.
Right. Would you consider it appropriate for Mr Moretus to have any role in matters concerning the refusal by your colleague, the Foreign Minister Bishop, to grant a passport to the former ASIS officer known as Witness K?
Well, Senator Madigan, how Ms Bishop exercises her power under the Passports Act to suspend or cancel passports is a matter for her, and in respect of which she receives advice from her department. Perhaps Mr Varghese could elaborate a little further on the procedure whereby the Foreign Minister receives that advice. I'm not aware that Mr Moretus was involved as the Secretary of the Attorney General's Department. I wouldn't expect that he would have been.
I can confirm that Mr Moretus was not part of the decision-making process in relation to that particular issue you raised.
Is there not a potential conflict of interest?
Well, not if he wasn't involved.
Okay.
A, not if he wasn't involved, and B, if contrary to what we believe to be the case, he had been involved, not on any of the premises of any question that have been accepted, Senator.
Thank you. Attorney, has there been a departmental review of the basis upon which former Attorney General Mark Dreyfus authorised the installation of listening devices in the home of the former senior ASIS officer, Witness K?
Well, look, Senator, first of all, that's a question to be asked in the Attorney General's estimates. Secondly, I'm not confirming that Mr Dreyfus did so. If that occurred, which I am not confirming, it could only lawfully have been done by warrant, and it is not the practice of the government to respond in a public forum to questions of the content of warrants issued by the Attorney General under either the ASIO Act or otherwise.
Last question, John.
Okay. Attorney, have you informed yourself as to the identity of any person who swore an affidavit in support of the issue of the warrant authorising the installation of the listening devices in the home of Witness K?
Well, again, Senator, I am not confirming that that was done. The question you put to me seems to flow from your previous question, which is about what my predecessor, Mr Dreyfus, may or may not have done. I would not ordinarily see any affidavit or statement sworn by anyone in support of a warrant issued by a previous Attorney General. So I'm not confirming that what you say is right, but in any event, it's not something I would know about if it was issued by a former attorney.
Thank you, Senator Madigan.